everyone, and welcome to the October 18th, 2016 Public Service Commission $4 million allocation. First on our agenda is a reading of the meeting minutes of October 6, 2016. Does any commissioner have any changes, corrections, or comments or anything about those minutes?
Yes, Mr. Chair, I do have a question. I'm a little confused in that the consent agenda items, the motion moved to put one item on the regular agenda, and on page 2, there is the matter of the joint application for call catchers, and it says commission to consider staff memorandum. Motion seconded by Commissioner Drexler, and motion carried 3-0.
That's because the commission doesn't take any action on it. It automatically, the time period, it automatically goes in that they're authorized to do that activity.
Okay, I think later there is also another motion related on page 6, which also shows action, which was the motion to request a hearing. So I see two entries. Is that appropriate on the?
No, one should be.
Okay.
The one on the consent.
Okay, so the first entry on this topic will be removed, and the motion that shows the action will remain. Okay. So on that, sorry.
Oh, wait a minute. That's right. It was to move it. The motion was to move to go.
So the motion was to move it to the regular agenda because that's not clear. Okay, it might make it clearer if that's stated. Okay, so on that basis.
Although, if I may, right after number 3, the first paragraph addresses the removal of that item from the consent agenda. And then the rest of the consent agenda is adopted. And then it is addressed in the regular agenda portion, which would be the scheduling of the evidentiary hearing.
So
am
am I confused, or does it make sense?
I believe what we can do is strike the call catchers paragraph that is right before number 4.
Yes, that was.
And that would address your concerns.
Commissioner Correa just raised a very valid point. Neither Chair Winslow nor he can vote on the minutes. They have to abstain because they were both absent at the last meeting, and that would leave 2 votes either in favor of and it's not a majority. So we can't adopt the minutes.
So, but I would recommend a revision, perhaps, and at the next meeting we can come back for adoption.
Yes.
Would that work, Mr. Chair?
Yes.
Thank you. No further comments on the minutes.
Okay, so we're going to reschedule the reading of the meeting minutes until our next commission meeting. The consent agenda. Does any commissioner wish to have any item on the consent agenda taken off? I should say while we're all here, talking, Commissioner Drexler is sick today and unable to attend. If not, then will someone make a motion to approve the consent agenda, please?
Go ahead.
I second it.
Now, let's have a first now.
Move that we adopt the consent agenda as presented.
Okay.
I second that.
That's good. Halloween. Pretty sharp start here. Okay, any discussion on the motion to approve the consent agenda? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Bigger than normal. It passes 4-0. Okay, the first item we have on the regular agenda, and our apologies to the rest of the agenda, but Commissioner Gray has an obligation for OPSI in Columbus, Ohio, has to leave before the end of the afternoon, so we couldn't put this last, so I apologize to the Artesian and the Suez and the other people on the calendar for not getting them out of the room. But you'll have the benefit of listening to some great arguments with respect to $4 million issue. And I think as I said, the first item is in the matter of the application of Belmont Power and Light, et cetera, for approvals under the provisions of the statute. Notice there. First thing we have to consider is staff's motion. And all the parties will be kind enough to come forward.
Mr. Winslow and Commissioners, before you get into that, just a little bit of advice going up front. I mean, as you know, the staff is seeking to have $4 million go to a public interest. You know the public advocate is opposing that. There was a quote of a Supreme Court decision, or it mentioned a Supreme Court decision in some of the paperwork. And I just wanted to tell you that the quote from that Supreme Court decision is concerning the phrase public use or public interest. And in that quote, the case really had nothing to do with this, but the case dealt with the standard of proof in an appeal. But in doing that, the court said the pivotal issue revolved around determining whether potentially regulated companies' activities had a significant impact on the public interest that the PSC was designed to protect, and that would be preserving and promoting indispensable services while preventing inferior service with excessive and discriminatory rates. The Supreme Court did make a statement as to what the PSC is concerned with, or what that's worth.
Thank you, Mr. Willard. Before we get started, where's hearing examiner Lawrence? He's here, right? Okay.
Back there in the corner.
Hearing examiner Lawrence indicated to me, and by the way, I'm not feeling terribly well myself, and I've been coughing like crazy, so just ignore me if I get a little sick here. But Mark mentioned to me that Donna Nickerson and Jason Smith, is Jason here? Here he is. And Ashley Lyon, is Ashley here? She's out sick today. Just did yeoman's work on this particular matter, and he wanted you to be recognized, and I thought that was highly appropriate. I want you to know that the commissioners and everyone appreciates all your fine efforts. So thank you very much on behalf of the commissioners and the commission. And the first thing under consideration, I guess, Mr. Geddes.
Thank you, Mr. Chairman, members of the Commission. First, I'd like to thank the Commission staff, the parties, and everyone else involved in this particular matter for the adjournment from October 6th to today. It was very much appreciated. With regard to staff's motion, in legalese, this is a belt and suspenders motion in the sense that on the one hand, if the Commission feels that the record should be open to consider some of the additional materials that were submitted after the close of the record on the 20th, the Commission can certainly do that. As I've suggested many times before, the Commission controls its own docket. And staff felt that perhaps since the hearing examiner had closed the record, a motion would be appropriate to open it to consider, if the Commission so chose, staff's memorandum and the other materials that have been circulated. So from staff's position, I don't think at the moment that motion necessarily needs to be decided unless, based on the arguments that you hear, you feel that there is some reason that you would want to open the record to allow all this material in. I would suggest that the RFP and the MOUs that are attached to staff's memorandum are additional indicia of what staff was thinking about in terms of trying to flesh out in response to the Commission's request that we put more specificity on this public interest issue. So I'm happy to proceed with staff's memo, or we can join the issue on opening the record. I don't think staff's position is inconsistent. Staff really filed the motion, as I said, to allow the Commission, should it choose to do so, to open the record again if it believes that it wants these additional materials in the record. I do think we can proceed with comment. And obviously, as I said before, on the 20th, this is the issue of public interest is a policy issue. It's not a fact-driven issue. And the commission is the ultimate decider of policy. And it can either accept these as comments or allow them to come in as exhibits. Thank you.
Thank you, Mr. Geddes. Ms. Iwari?
Thank you, Chair Winslow and Commissioners. The DPA has opposed staff's motion for a couple of reasons. First, we find that the motion to reopen the record to allow these comments and their attachments in as exhibits is directly contrary to the position that staff took with respect to Dr. Firestone's request at the September 20th meeting to have his second supplemental testimony admitted into the record at the September 20th hearing. There, staff argued against admitting Dr. Firestone's testimony as part of the record and said, as Mr. Geddes has said, that the issues that the Commission would consider were policy issues that did not require evidence. The Commission agreed with staff's position, and Dr. Firestone's supplemental testimony was not included as part of the record. Rather, the Commission considered that testimony as comments in the same way that it considered the comments that the other parties filed and argued. But staff now wants its comments, which are not even filed testimony sworn to under oath, to be made part of the record. Now, we do understand that at the September 20th meeting, the Commission asked for additional information regarding staff's public interest proposal, but we would submit that this is information that could have and should have been included in one of the two opportunities that staff had to provide comments on how it believed the most favored nation funds should be allocated. Under the procedural schedule, comments were due on August 12th and September 12th. Staff proffered this proposal in July, but has not explained why it did not include this material in the record in any submission due on August 12th or September 12th. And we believe that it is too late in the game for staff to be fleshing out its proposal now. Again, I don't know whether you want to just leave it at that. We do have comments on the additional information or on the additional comments that staff has filed, or do you just want to deal with the issue of the motion right now?
Dr. Firestone?
Just a clarification on my supplemental testimony and how it was handled. It was, in fact, admitted into the record. Staff filed a late objection past the procedural schedule. Ms. Iori is correct that they did say that it was not appropriate. Because everything was policy and there shouldn't be additional items into the record. The hearing examiner denied staff's request to bar my testimony because they filed too late. And so it was, in fact, admitted into the record. But it doesn't take away from the argument that Ms. Iori made about staff's sort of switching now views that they should be able to supplement the record rather than solely have whatever they're submitting go along the lines of comment. As someone who generally believes that openness and argument is fine, I don't personally have an objection to the information per se. As I indicated in my comments, I think the staff's comment is misguided, but I don't think it will matter too much whether you consider that misguided information comment or evidentiary material. Thank you.
Mr. McGonigal?
Thank you, Mr. Chairman, members of the Commission. I think Professor Firestone's recollection of how his testimony was handled is correct. I think it was admitted into evidence over staff's objection. We made the argument in that context that there was not a significant difference between advocacy and evidence in this context, and we did not object to Professor Firestone's testimony being admitted, and we had the same position with respect to staff's submission as well. Thank you.
Thank you. Ms. Scott?
Oh, good afternoon, Chair Winslow, Commissioners. DENRAC doesn't take a position on this issue.
Is that all the parties, I believe?
Commissioners, my apologies if I misrepresented the record and the stand and where it is now. I did not remember Dr. Firestone's testimony being admitted. Clearly, everybody else remembers otherwise, so I do retract that part of my argument.
Okay, thank you. Any commissioners have any questions of the parties? I mean, we need the input. We can't really proceed on this docket without talking to you all about your thoughts and feelings about how this money should be allocated. How are we going to do our job without you guys helping us out and telling us a little bit more about your proposals? I mean, as far as I'm concerned, we're just going to let it hang out, and we're going to listen openly and to all the ideas you got around the table, and then we're going to make a decision. So I'm not sure how we could do it any other way. If we don't let the information in, we're not in a position to make a decision, at least not a good decision. So that's my inclination. I'm not sure how the other commissioners feel, but I would move that we permit the. Well, I don't even think we need to reopen the record, so to speak. It's sort of, we're like in the decision-making process right now, not necessarily the record-making process. So I think we should just maybe accept Mr. Geddes' offer, which does not address the motion at all at this point in time. Let's hear the arguments from the party on the merits of the allocation, and then we'll go from there. Is that okay, commissioners?
Completely agree, Mr. Chair.
I think that we should start with Mr. Geddes.
Thank you, Mr. Chairman, members of the Commission. In response to the discussion among the commissioners at the meeting on September 20th, staff did attempt to go back and put more specificity on its proposed $4 million public interest fund. In context of where we are, after almost 2 years, maybe more than 2 years, we have allocated, or the Commission has allocated, $67 million of approximately $71 million benefit. And so we're at the last stage, if you will. You can mix your metaphors, mouse and the snake, or on the goal line, but we're almost to the finish line, if we use the football analogy. And so I think in that context, it's important to note that this one idea, which has obviously gotten a lot of pushback from some of the other parties, is one that staff does feel is important. And we did make an attempt in the memorandum that was dated the 29th to address the specific concerns, and I believe it was Commissioner Gray, who suggested that there was not enough in the proposal to accept it or reject it. Now, Commissioner Drexler, I believe, was the one who at least found the idea of not allocating all of the money at the present time, one that she could initially support. And there was some other discussion back and forth among the commissioners. And ultimately, it was decided by a vote that staff should go back and put some more meat or more specificity on the proposal. And the memorandum that we sent you was an attempt to do that. Now, at the end of the day, it's the Commission's authority as well as privilege to decide whether staff met that burden, whether we addressed your concerns adequately, or whether, based on the comments of others, that staff's proposal misses the mark or perhaps is ill-advised. But it was a careful attempt to try to address what we thought were the Commission's concerns, with language with regard to an RFP, language with regard to MOUs, and other materials that one might consider if we were going to follow staff's proposal here. What I find most curious is that this $4 million proposal in the context of $71 million worth of benefits has seemed to take a life of its own. If you read the DPA's materials, and first of all, Dr. Firestone said that staff's proposal was misguided. Actually, Dr. Firestone called it a perversion. Now, it is the silly season, and I know that people use words in different contexts, but it may be many things, but I don't think it's a perversion of the public interest. But I will just go with the misguided, perhaps, for Dr. Firestone. But with regard to Ms. Iori, and they'll come after me, so I'm taking a little liberty in trying to address what I believe will be their arguments, having read their materials. Ms. Iori, who I've known for more than 30 years, and who is one of the best writers, if not the best writer, who shows or appears or otherwise practices in front of this commission. I have been a big fan of her writing for decades. But I will suggest that this particular piece of material, in the context of the issue, is, at least from my personal observation, a little over the top. She suggests, as she did in her initial comments about opening the record, that staff should have presented more material initially, that they had an opportunity in August, an opportunity in September, and we didn't do it. Now, you recall my argument or comments on the 20th when I said, well, we realized that there was opposition to this, and unless the commission was interested in it, we didn't want to spend a lot of time and resources developing a concept if it wasn't going to go anywhere. But then in the next paragraph, she says, and this is paragraphs 11 and 12 in her opposition papers, page 4, moreover, it is irrelevant that staff circulated a draft RFP. Staff knew the DPA disagreed with the proposed allocation of MFN funds. Why would the DPA waste time submitting comments on the RFP drafted to support a proposal with which it disagreed? Now that reminds me of the John Kerry windsurfing political ad in 2004 when he was alleged to have said, I was for the war before I was against it, as he was tacking off Martha's Vineyard. I mean, on the one hand, she's saying, we're not going to pay attention to it. And the other hand, she said, well, you should have given us more material so we could reject it. I mean, I do think that's a little bit inconsistent, which I think either this is a proposal that the commission believes has merit or does not. But it shouldn't be a cause célèbre. I mean, in the sense is it's a very small part of a much larger process that we're almost finished. And so rather than trying to go through the various parts of staff's analysis, it's for your consideration. And if you think it has merit, then we would ask you to approve it. If you think it does not, then the commission can decide how better to allocate the $4 million. You heard on the 20th a comment from Dito, the representative, about a new technology center. That was one idea that was thrown out then. Staff also, when asked, went back and said, well, maybe you'd split the $4 million between some of the various categories that were on Exhibit 54, the chart, what I call the chart. Or one could merely refund it to ratepayers. I mean, there are plenty of things that you could do with the $4 million should you choose not to support staff's proposal that this be reserved for public interest projects that would be developed over time. Thank you very much.
Thank you. Ms. Iori, and we really are interested in being able to hear about the proposals themselves, not the tensions between the parties over procedurally what happened. We really would like to hear about the programs. For example, Ms. Iori, if you would tell me a little bit more about your aspirations for the $4 million in terms of, I know obviously we know the entity you're proposing to go to, but what do you foresee the entity doing with that $4 million, and how soon would it happen? Just get a little bit of meat to the bones of that. I'd appreciate that.
Oh, our proposal was that it go into the EEIF, which is already getting $4 million that the commission approved on September 20th. I don't think there's any more meat that needs to be put on those bones because DENREC will get the money and disperse it according to its, trying to think of the right word, it has criteria for eligibility. That criteria has been established. It's in writing. Everybody knows what it is. And they will distribute those funds according to those criteria.
Fair enough.
I appreciate Mr. Geddes' kind words about me. I have nothing but respect for Mr. Geddes as well. He was my mentor, and he is now my good friend, even though in this particular case he is my adversary.
I'm glad we got that clear.
Just a couple of things. Staff says that it's curious that a $4 million proposal has taken on a life of its own. For the DPA, it was never about the amount of money. It was about the principle. And as we argued last time we were all gathered together, we don't think it's appropriate for the commission to be picking winners and losers with this money. And that's what you would be doing here. Because despite what staff has said, that it would actually be Delmarva or Exelon or the joint applicants who would decide who got the money, I think what you saw is that in their submission is that the joint applicants really don't want to have anything to do with it. They have said that their preference is that Delmarva Power not be charged with evaluating programs or making awards for specific projects. They note that Delmarva and its employees currently support a number of programs and activities in the communities they serve. And they go on to say that to have Delmarva Power undertake such a role might create an impression that Delmarva Power unduly favors certain programs over others or is otherwise vested in specific public interest allocations. To avoid even an appearance of bias or influence, Delmarva Power would prefer to have no decision-making role in the allocation or award process, should the commission determine to allocate funding to public interest projects. Well, if Delmarva doesn't want the responsibility, but staff wants there to be somebody who makes the has the responsibility, I guess that leaves you. And we have as I said, we have a problem with that for the same reasons that Delmarva has identified. Does the commission really want to be involved in picking winners and losers? I don't know that you do. If you do, and I'm wrong, so be it. But I don't know that this commission wants to get involved in that kind of minutia.
Why don't we just give the money to the Grants and Aids section of the Joint Finance Committee and tell them to divide
You could
it up?
do that too. I mean, in fact, money that comes into the state from something like this would generally, in the absence of a specific endowment, it would go into the general fund
Now,
under state law. So,
the only problem I have with that is I guess we'd have to put a deadline on it and ask them to do that in January. And if they don't do that in January, have some sort of a backup program as to where the money would go. Because we don't want them to spend $4 million less. We want our $4 million probably to go to a good public use. And anyway, okay.
well, the commission could avoid that by saying this $4 million goes to the EEIF. That's a specific endowment. Now, the DPA's now staff has also argued that the DPA's position that ratepayers should get most of the benefit of the merger because they created the value of the merger, quote, does not consider the value contributed and retained by the merging utility for the state of Delaware, end quote, and that staff's proposal that less than 6% of this money, the whole amount of money, be reserved to enhance Delmarva's public interest is reasonable. But the DPA's position that this $4 million should instead go into the EEIF does consider the value contributed and retained by the utility for the state's benefit. The General Assembly itself has decreed that costs that Delmarva ratepayers pay for various energy efficiency initiatives benefit the entire state. We pointed out in our papers that in the Energy Efficiency Resource Standards Act of 2009, The General Assembly found and declared that the benefits of a strong focus on cost-effective energy efficiency accrue to the public at large. And those benefits include many things, such as less money spent on energy, improvements in local air quality, etc. So the DPA's position that the $4 million should go to the EEIF does create value for and benefit the entire state. We further believe that even with the additional detail that staff includes in its comments, the proposal is still too vague. In answering the question that what public interests will be entitled to submit a bid, staff says services, programs, or projects that are in the public interest of Delaware citizens. With all due respect, that is a circular argument. The public interests that are eligible to submit a bid are public interests. Furthermore, for the reasons stated in our comments, the DPA is concerned about staff being involved in the selection of any independent evaluator or being involved in any evaluation of bids received. Finally, staff's proposal that Delmarva or Exelon be the ultimate decision maker, a role that Delmarva and Exelon clearly do not want, is inconsistent with the RFP that staff included with its comments that purports to support its proposal. That RFP clearly contemplated that the Commission, not Delmarva, not Exelon, would be the ultimate decision maker. I'm not going to go through all the examples of these inconsistencies. They're in our papers, but it is. We just wanted to point out that staff's original proposal is not the same proposal that it's advancing now, with respect to who is ultimately responsible for doling out the funds. So for these reasons, as well as the reasons that we argued on September 20th, we respectfully urge the Commission to reject staff's public interest proposal and instead allocate the $4 million to the EEIF where it will benefit the entire state. Thank you.
Thank you, Ms. Iori. I don't know enough about how much money the EEIF is able to spend in a given year in a prudent fashion. So I don't know if DENREC's going to be able to let me know that or not. I'm not sure if we're going to overwhelm them with money, so to speak, if we were to award the entire $4 million to them. And Ms. Iori, how about something a little bit more innovative? How about we jumpstart the electric cars by having these chargers that Dr. Firestone wants? Wouldn't that be something that would be innovative and hopefully put some assets out there that people could actually use and promote that sort of an activity?
The DPA would prefer that than as opposed to something that staff has proposed, having the Commission dole out funds to particular charities or governments or whatever. But the DPA is not a big fan of Dr. Firestone's proposal.
Fair enough. I gathered that. But Dr. Firestone, you get to defend yourself.
Yeah. We think if the idea is to get a broad base of Delawareans to benefit from this money, we think having electric car charging stations is probably way too limited for that.
Good afternoon, Chair, members of the Commission. Public Advocate and I disagree on some things, but actually we agree on most things here. And that should tell you something. Anyone who's followed this over the past couple of years. So I think that's point number one. Point number two is the only ones who made this a cause celeb is staff. Staff, despite the chair at the last meeting suggesting, for example, to staff that it consider my proposal regarding wind and solar research and electric vehicle charging. Now, talk to me. There's nothing in their proposal that even seems that they considered it. They are the ones that have gone off on their own, just as they went off on their own with the DITO, and have made a lot of these things cause celeb rather than trying to come to agreement amongst all the parties. I think it's interesting if we look at who doesn't favor this proposal. The joint applicants, the Public Advocate, me, Clean Air Council. MAREC did not file anything, but if you look at their earlier filings on the public interest proposal, they suggested that it be limited to renewable energy. So who's in support of it, this broad notion that we should create a social welfare charity? And, no one's against social welfare charities. Many of us give and donate to social welfare charities, including, Delmarva Power. But the question is that an appropriate role for this commission? And I would submit that this commission is a body of limited jurisdiction. It's not a body of general jurisdiction. It can't advance prerogatives that are beyond commission authority. And that goes to the issue of, you've got to look at your mandate, your jurisdiction, what you can do. If you look at that, well, Public Advocate says we should go to the EEIF fund. That's consistent with your mandate. And just on the issue of the amount, initially the General Assembly funded it at about $5 million per year. So if you were, in fact, to add $4 million, you're basically making the program go for about 2 years rather than 1 year. It doesn't have to all be used up at once, and in general, the parties have considered sort of 5 years as an implementation time frame. So I don't think you need to worry about that in regard to whether you want to go with the Public Advocate's proposal. It basically converts a merger that's about the delivery of electricity and natural gas in this state into a giant slush fund that Delmarva Power, and part of the perversion is not just that we're making this a general fund that's much broader than your mandate. It's that Delmarva Power is supposed to do an RFP and make decisions on whether the governor, Office of the Governor, for example, puts in a proposal, and they're supposed to decide whether to give that money or not. They're supposed to decide whether to give money to DITO. They're supposed to decide whether to give money to DENREC. That's not a position that a regulated entity should be put in. It's not, it doesn't reflect well on, it would not reflect well on this state. It would not reflect well on this body. And I would suggest that you really narrow your benefit, your focus. I believe that electric vehicle charging, I suggested 500,000, not the 4 million. So let's just first start with that a portion of that money go to electric vehicle charging because it will help jumpstart electric vehicle purchases in this state, and that will be good. DENREC has some programs related to electric vehicles, but not the kind that I am suggesting here.
Dr. Firestone, I think that Ms. Iori makes some good points about the electric car recharging things, but it seems to me that if you, and of course this is not on the record, but I'm just saying that if you look at Tesla, now they got an electric car that can go over 300 miles to a charge. General Motors just announced the Bolt's going to be coming out. That's going to be able to go 238 miles. You can drive back and forth in Delaware about 3 times with that charge. The penetration of electric vehicles is going to just increase. If we had time of use rates in Delaware, PG&M is going to sell us at 3 o'clock in the morning electric kilowatts for 5 cents a kilowatt hour. I mean, it seems like to me that if you wanted to make an investment, and you wanted to make a difference and spread some of that money in a general sense, I think that you've got some merit in what you're talking about.
I mean, it would be like saying, well, we could eliminate 95% of the gas stations in this state because people could always drive and reach a gas station because you can go 300 or 400 miles in your car. That's not the way. We've got a gasoline infrastructure in this state and in this country. And if you want to put electric vehicles on a more even playing field, you have to start building that infrastructure in this state as well. It doesn't matter that the car can theoretically go to, some cars can go 238 miles. Others, that are on the road right now can only go about 120, and people want to be able to have the assurance that they can go further. The other thing is that the 230 miles is when it's warm and in the summer. Cold and in the winter, that car is not going to go 230 miles. It's going to go significantly less, particularly if it's not garaged, because you use a lot of battery power to warm up the car. So, and we have that same experience with the electric vehicles that go between Newark and Lewis. In the summer, we can make it without stopping. In the winter, you have to stop in Dover and top off because you can't make it. You get significantly less mileage. So, again, this would really move our state forward as well. The wind and solar, as I indicated, we recently released a report which suggests that we could develop wind in this state for a levelized cost of energy for $70 a megawatt hour. I looked at Sussex County. It's probably true in Kent County as well, where we have farmlands. It would benefit our farmers. There's a lot that you could do around that, and same thing with trying to understand where you might put commercial solar. So there's things that can be done to advance energy policy, and when you do these kind of things, if you bring in renewables, you're going to have price suppression benefits because they lower. When Delmarva Power has to go on the hourly markets, when you have wind and solar, you lower the market clearing price. So there will be benefits to everyone if we're able to implement this. It's certainly going to be more of a benefit to ratepayers than giving the money to, for example, Goodwill or to some State Department, et cetera. It also, if, as I had suggested, that I would try to get the university to run this RFP, that would get around Ms. Iori's concern that the commission had some role in picking in winners and losers. People are experienced in picking winners and losers related to RFPs. And there's some set processes, and they use external reviewers, et cetera. So any approach from mine to Marex that said renewable energy RFP, to the public advocate who advocates for energy efficiency, to my backup, which was give it to low-income ratepayers, or if you think that's too complicated, just to all ratepayers, any of that would be superior to staff's proposal. And for the life of me, I can't understand why DENREC supports that proposal rather than one of the proposals of the parties that are advocating for renewable energy and energy efficiency. Thank you.
Thank you, Dr. Firestone. Mr. McGonigal.
Thank you, Mr. Chairman. Tom McGonigal, representing the joint applicants. I just want to make sure that the Commission understands the joint applicants' position here. We continue to believe that utilizing these funds for public interest projects is consistent with the public interest. We think doing so creates a mechanism by which we could get input from the nonprofit community. And the basic idea here, I think, at least in terms of our support, was that folks in the nonprofit community might have ideas that are not been presented in this room with the parties, and that this process would allow for those ideas to come forth. So that's the reason why we've been supportive. When this proposal was first put forth, we did talk about the idea that Delmarva Power did not want to be a decider with respect to these funds. We've agreed that will be helpful in terms of administrative support, but we did not want to be deciders. One of our fears was that if we were in a decider role, we would be subject to allegations of conflict of interest and slush funds and things like that, some of the things you've already heard here today. And so that we did not want to be in that role, but we do support the proposal, but we don't want to be a decider. When staff submitted its proposal or its submission on the 29th, they included, I think, as an alternative option that Delmarva would be a decider. And that's what sort of triggered all this back and forth, and that's why we submitted our response. I believe it was an alternative option. I don't believe it was the only option, but it is an issue that we do have a concern with in that sense. One of the things that has been talked about here is that there's this sort of giant slush fund. I think it was equated to the Ford Foundation. I think we have to have some perspective here. This is $4 million out of 71 total, less than 6%. The Ford Foundation, I think, reports about a $12 billion endowment fund, so it's a little bit out of whack in terms of some of those suggestions. But again, I think our position, as we originally put forth, holds today. We think there's some untapped value in terms of the nonprofit community that these funds could be utilized for, but we do not want to be deciders when it comes to how those funds get allocated. Thank you.
Thank you. Ms. Scott?
Yes, Chair Winslow, Commissioners. DENREC is on record in support of staff's proposal, and we don't have anything else to offer in terms of some of the alternatives that have been discussed today.
Thank you. Well, what do you think, Commissioner Gray?
Thank you, Mr. Chair. First of all, I'm going to thank the staff for bringing back more information and the other parties for bringing their perspective to the table around this topic. I may have a somewhat unique perspective on this in that in a prior life I raised money statewide for the United Way of Delaware and sat at the table as decisions were made in the public interest to award monies for projects. From what I've read, and I could be wrong, and any of the lawyers can correct me if I misstate this, but I don't see the public project selection as being core competency or responsibility of the Commission. And for many of the reasons that have been laid out here, and the joint applicants really don't want to decide, and I think I appreciate why they don't want to get in the middle here. I do think that there are some meritorious suggestions coming from Dr. Firestone, but again, it comes down to the question, for example, if we suggest that this money be invested for expansion of electric vehicle charging infrastructure, how much of the public is going to derive a benefit from that? I don't think it would be as broad a public interest as some other options on the table. I did read and hear our counsel prior to this discussion say that there are some precedent that the court recognizes this commission should contribute in ways that are core and germane to the responsibilities that we have in the energy or the utility sector. And so the idea of a public interest that has the option of stepping outside of that narrow framework for me is a little bit troublesome. So my view on the overall issue, even also Dr. Firestone's suggestion that a university should play a role. Well, if one were to pick one university, it seems to me that might be prejudicial. But if one were to then select multiple universities to engage, that would raise the level of complexity for oversight, management, performance at the end of the day that might get a little bit unmanageable and unwieldy. So my leanings on this matter are in the direction of the public advocate, that these monies should go to something that is either energy efficiency or the Sustainable Energy Trust Fund, something that could be seen as a much more broad application of funds that derive to a much more broadly stated public interest in the end. I don't have any other questions or comments, Mr. Chair. Thank you.
Thank you, Commissioner Gray. Mr. Correa?
Mr. Chairman, I also agree with Commissioner Gray that the money should be going to or should be used on a wider scale, number one. And number two, the Commission should not get involved into getting RFP and getting people here and hearing and then making a decision, because our core competency is really what we do every day here. Rather than expanding that core competency, we should develop that core competency deeper on our part, time-wise, money-wise, staff time-wise, and what have you. So far, what I have heard is like three proposals, and Dan Rex fourth idea, and what have you. So that doesn't seem to be any direction. And we have to make a decision, even though it's 4 million is like out of 71 million is finish line and windsurfing and all those things. Maybe I'll give up playing sports, so you will not quote other people. But
Maybe I need to pick another sport.
But I think that we should be able to conclude. Even we are unable to conclude this. How can we ask for RFP and go through the process for 10,000, 100,000, 50,000? So we should be able to conclude, and I'm very, very, even the public input is welcome, and it gives us ideas and new blood and new thinking and new aspects of life, community life or people's life. It is disappointing that for $4 million, where every dollar counts in a small state like ours, we are unable to come to a very smart conclusion, like a smart car. We don't have a smart conclusion, and I don't know. I'm at the wall, not banging my head yet, but I think that time will come. But we have to have some conclusion here. Otherwise, this will go on for another 2 years and 5 years. So,
And the money will be
that's
gone.
it. We don't want. Yes.
Commissioner Conaway.
Well, I'm going to take a tack completely different from all of you. Mr. Geddes is left.
Sorry.
I've listened to all of the arguments, and I have seen the facial expressions as they all wonder who's doing what. And this is $4 million. We talk about it like it's 5 cents. In $71 million, I guess it's a small amount. But after listening to all of you today, my vote would be to give it back to the ratepayers. It gives them full use of the $4 million. Nobody gets any administrative money. Nobody gets anything else. Nobody argues over who it's going to benefit. It's going to benefit the people who pay for the electricity. And that's where I am.
Yes, I would agree with you.
Well, Dr. Firestone, you're invited for a loser's glass of beer at the local tavern with me after the conference, I think. I do think that spending some money in that area might help kickstart some things and some actions. But, I guess nobody else feels strongly enough about it. I certainly don't support the state's proposal, and I do, like all the commissioners, appreciate the fact that the staff went to a lot of trouble to give us some more information on that. But I'm just uncomfortable with the whole idea of handing out money in the way that was proposed, and also to the whole world of the nonprofits out there. And of course, I know they all need that money. But we have the uncertainty of what kind of programs are going to come up and the oversight of it. It just looks like it's going to be a morass to me. So I can't support that. I would support what Commissioner Conaway says, but I'm not sure that we're, in a general way of speaking, I'm not sure how much an individual consumer is really going to gain from that money-wise. I guess it'll probably pay the Bloom charge. See, Bloom charge is about 2.5 or 3 million each month, so it would pay the Bloom charge for a month and a half. That's one way to look at it. So that would be $4.53 plus half of that, so that'd be about a $7 improvement for the consumers, which I'm sure it would be appreciated by any consumer who gets the $7. But I think that the more bang for your buck is going to come from giving the money as the a public advocate has suggested, because at least that way you're going to get energy efficiency, and that's going to be, you're going to get more than a buck for your buck. So that's why I stick my support in that arena. I appreciate very much Commissioner Conaway's attitude. That's what I felt initially, but I do think that we'll get more bang for the buck. And so what I'm going to do is I'm going to put a motion on the floor, since we're probably talking before we really have a motion to consider, which is fine. But I want to move that the Commission allocate the $4 million as proposed by the public advocate. Is there a second?
I'll second that, Mr. Chair.
Any further discussion on the motion?
Yes. One clarifying question to the public advocate, because I believe in their proposal there were one of two places that the money should go. I think it was either the Energy Efficiency Fund or the Energy Trust, Sustainable Energy Trust. Can you clarify which one you have in mind?
It is, I may need a little help from DENREC on this. I know that we had what we called Energy EEIF Plus, which was, I think, for large commercial and industrial.
Right.
And then there's the regular EEIF, and I believe that we had wanted it to go to the regular EEIF. So that would be for average people, not
Okay.
large commercial
Yeah,
and
that
industrial.
was my intent, because that's the argument, that's the alphabet you used in your argument.
Right. So, and I have one further question for Ms. Iori. While we're pending this motion, as you've heard Commissioner Conaway propose giving the money back to the ratepayers, how do you react to that as an alternative to the motion we're about to consider?
Well, before we came together with a proposal that most of us supported, the DPA's position was that it should all go back to ratepayers. I think we eventually concluded, as Chairman Winslow did, that it wouldn't, 4 million divided in, by the number of Delmarva customers would not be a significant amount for people, and that, as the commissioner, as Chair Winslow has said, we could probably get more bang for the buck if we put it into the EEIF, because ratepayers do pay for energy efficiency programs under other state mandates. And so we thought that this would perhaps be a way of reducing the amount that ratepayers pay for those other state energy efficiency mandates.
Thank you. No further questions. Thank you, Mr. Chair.
Commissioner Conaway?
I do have a question. It seems to stick in my mind that the number of customers served by Delmarva is 300,000 in the state of Delaware.
I think with gas, it's closer to 325 or around there if you include both electric and gas, Commissioner Conway.
And I'm not working with pencil and paper, but I'm thinking that $4 million divided by 300 and some thousand customers would be $100 a customer plus.
No, your math isn't good.
Well,
How much?
About $13.
$13?
Yep.
Okay. Yeah, 10. Okay. Without the pencil and paper, all right. So,
we have Mr. Goodman, and he says $13. So
Okay.
I trust
Per
him more
residential-
than
per
pencil.
residential
Per
customer.
residential customer.
$13.
Per resident. So it would be a little less if you gave, industrial large commercial is a small percentage of total customers.
All right, I had the extra zero
Yeah,
on.
yeah,
That's where I was headed. Okay.
Any further comments by commissioners on the motion?
After hearing the discussion from public advocate and from your point of view is going to the general public anyway, but we will have more bang for the buck. I'm in favor of that.
Well, I respectfully request that you vote yes then.
Yes. So I second it.
Okay. All those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries 4-0. Thank you all very, very much.
I had the extra zero for some minutes.
The next item on the calendar is in the matter of the application of United Water Delaware Incorporated. Oh, I'm sorry, I apologize.
Point of order.
Mr. Geddes? Point of order over here, Commissioner Gray.
Is there not a discussion with the parties regarding the revised language?
Yes,
to the
that was
agreement?
what I forgot.
Is that a party to this agenda?
Yes.
And that's what I was trying to get clarified, that I believe there's one other item in this.
You are absolutely correct. I was remissed, or trying to pervert the system, I guess, by going over that. Getting this proposed order number 8952. Thank you, Commissioner Gray. Non-financial terms, Mr. Geddes, are you going to carry the water on this one?
Oh, I'll let the company carry the water on this one, since I believe that they have an interest in it.
Okay.
Yes, thank you, Chairman Winslow and Commissioners. The order that you have in front of you, 8952, is the product of a lot of back and forth, mostly between Mr. Geddes and Mr. McGonigal and me, but also involving Ms. Iori. What happened was in March, this merger was approved in the District of Columbia with many conditions, and after that, when we got together with staff identified several things in the D.C. order where the language was different from what was in our amended settlement agreement. In some cases, it addressed a subject matter that had not been addressed in the amended settlement agreement. In some cases, it addressed a subject matter, but there were additional concessions, and staff thought that those were appropriate to have in Delaware as well. So we exchanged some drafts and sat down and went back and forth through this and tried to come up with an order that reflected the Delaware language and put all of these commitments in Delaware kind of at the same level, set at the same level that were provided in the D.C. order. And we had a productive discussion about that, and the product of that is Order 8952. And if you like, I can give kind of a general overview of what's in there, and certainly to the extent any commissioner has questions about a particular paragraph or particular language, we're happy to address those as well. There are additional reporting obligations reflected in 8952. There would be an annual report on jobs and attrition at the utility level in the state of Delaware. There would be an annual report on workforce diversity and supplier diversity. That would last for 3 years. There would be an annual report on economic benefits associated with the merger. That report would be in place for 5 years. There would also be an annual safety report that would go on indefinitely. These were all things that were in the D.C. order, and again, staff thought it appropriate that they carry over into the Delaware order, and the joint applicants had no objection. I do know from being around here enough that to the extent the commission wanted a report on just about anything, they could ask for it. But we were happy to make these commitments match what had been ordered in the District of Columbia. Another thing that this includes is an obligation for Exelon to consider Delaware as a place for the meetings of its board of directors, its stockholders, and its executive committee. In the existing amended settlement agreement, there was a general reference to the PHI service territories. This says that Delaware specifically will be on the list for those meetings of Exelon's board, executive committee, and stockholders. There are a number of technical changes related to accounting for the merger and synergies related to the merger. And I can go into as much detail as you want, but again, with the other commitments, this was a situation of staff looking at things in the D.C. order, and I assume discussing it with their consultants and wanting us to match what we did in the District of Columbia with what we're doing here. So there are now requirements in this order that synergy savings will be flowed through to customers as part of the rate-making process. There's also specific requirements that, for instance, if an Exelon utility were to get a notice from FERC concerning its accounting, or a notice from another regulatory jurisdiction concerning its accounting, its allocation of costs. It needs to notify you, notify staff, notify the public advocate, and have a discussion about that. There are some additional changes along the issue of ring fencing. Again, I think most of what is included in this order was addressed, the subject matter was addressed in the amended settlement agreement. But again, we wanted to align the specific language of what we're doing and obligated to do for this commission with what we're obligated to do in other jurisdictions, and that wasn't a problem. There are provisions that require that Delmarva Power have a chief executive officer who's knowledgeable about Delaware and is involved in rate making and other regulatory decisions here. There's a specific provision that says there will be a regional president of Delmarva Power who will maintain an office in Delaware and have a presence in Delaware and be involved in rate making and regulatory decisions here. There's also a provision related to reports on performance among the Exelon utilities. That wasn't a particular issue that was of great concern here, but in our other jurisdictions, there was a notion that we want to be able to compare one utility to the other. So this would provide for an annual report that will have performance comparisons among the various Exelon utilities, and that'll be filed in other jurisdictions as well. There are a couple of additional paragraphs. You will recall that at the September 20 meeting, there was a discussion about the 5 megawatts of renewable power that Exelon would commit to establish here in Delaware. There's language in paragraph 31 of the exhibit to the order that basically adopts the same language that was adopted in D.C. with respect to that commitment. You already approved the 5 megawatts of renewable power to be developed by Exelon. This just adopts the same language around that was adopted in the District of Columbia. There's also a paragraph related to the $3 million capital program, which again you discussed at your September 20 meeting, and this just adopts the same language that was adopted in the District of Columbia on that issue. That's an overview of everything that's in 8952. I'm sure Mr. Geddes or Ms. Iori are familiar with this, and if I've left out anything, they'll be happy to add to it.
Mr. Geddes.
Sure, members of the commission, unless you want to talk about tax indemnity, paragraph 15 on page 4, I believe that counsel for Exelon has done a very adequate job in trying to summarize a rather complicated document. The predicates that he has stated are the ones that are most important in terms of trying to marry up these two different decisions so that they comply with the most favored nation provisions in the amended settlement agreement. Thank you.
Thank you. Ms. Iori?
Thank you, Chair Winslow, Commissioners. The DPA has nothing to add.
Ms. Scott?
We have nothing to add.
Any other parties so present? I guess not. Commissioners, any questions?
Yes, Mr. Chair. Thank you very much for that overview. I appreciate it, and the additional work that you needed to do to consolidate this agreement. I do have a concern and a question. First, a question. The Exhibit A with this order, as I understand it, are terms that are added to the amended settlement agreement, not replacing or displacing the amended settlement agreement. Is that correct?
That's partially correct, Commissioner Gray. There are provisions where we say that because we've adopted language that is more expansive than what is in the amended settlement agreement, the provisions of this order say this paragraph will revise and supersede the paragraph of the amended settlement agreement. And just to give you an example, if you like, Commissioner Gray, paragraph 1 says Exelon will include the state of Delaware among locations for meetings with its board of directors and its annual stockholders meeting. Then it says this paragraph revises and supersedes paragraph 14 of the amended settlement agreement. Paragraph 14 of the amended settlement agreement said that Exelon would consider the PHI service territories generally for meetings of its board of directors and meetings of its stockholders. So in Exelon's and the joint applicant's view, it was very important that we have one standard that we can look to, and we don't need to look at one paragraph and figure out which one trumps the other. So that's why that's included in some spaces in this order.
Okay, so let's stay with Exhibit A, same page, paragraphs 3, 4, 6. In each of those where you have employment and workforce reporting, you have a 5-year duration for providing that feedback and tracking or fulfilling those obligations. Why has only 3 years been selected with regard to workforce diversity reporting? Why is not workforce diversity reporting reconciled to 5 years like the rest?
The only reason I can give you, Commissioner Gray, is we weren't particularly creative, and we took the District of Columbia language wholesale from what was there, and it was a 3-year reporting commitment in the District of Columbia. I can tell you that I certainly know Exelon takes its workforce diversity and supplier diversity very seriously. They publish an annual company-wide report that is comprehensive. I know it was the subject of some discovery and discussion in this case. And my guess would be that if this commission wants a report on workforce or supplier diversity forever, I would think Exelon, in many cases, would be very proud to present that to you because they do an awful lot of work in that regard.
I would love to see that, say, 5 years in reconciliation to all the other periods that you have addressed within this sample. I'll pause for a minute. Chair.
I'm just great.
Line of questions.
Gloria got every one of those.
Okay, so yes, I'd love to see that at 5 years. I just think it makes sense as I read through the rest of this document, and I'm hopeful that you're in a position to actually show this with respect to the Delaware implications here for diversity. I think that will feed into a view of what the merger can help us do with our workforce as well as economic and diversity development.
Commissioner Gray, your point is very well taken, and this is probably a rare instance where I can say Exelon, without even asking my client, I can say that they would be willing to provide this report because it's something they do internally on a very rigorous basis, and I'm sure they would have no objection to a 5-year commitment.
Okay. One other, and I believe last question here, is I was comparing these documents with the amended agreement and the revised agreement. I recall that before the merger vote was taken by the commission, I was curious to inquire about the ring fencing evaluation and assessment and analysis. And I think your settlement was in March, and 180 days from the settlement, there was to be a ring fencing analysis and report. Can you address the status of that report as of today?
Commissioner Gray, I've got, in general, I can. There was a requirement that there be, I think, a legal opinion provided that the ring fencing would be effective and this bankruptcy remote entity that had been created would be effective at separating the interests of Exelon at large from the utility. I believe that that opinion has been finished, finalized, and filed with the commission. And that was one of the major reporting elements. And if you don't have it, I'm 90% sure it's been filed with the commission, and I can arrange to get it to you, or the commission can.
Okay. So is there anyone on staff who is aware that this has been received?
Yes, it has been received.
Okay. Very good. I don't have any further questions, Mr. Chair. Thank you very much. I appreciate that insight.
May we have a motion on proposed order 8952?
Mr. Chair, I move that the commission adopt order number 8952 as submitted.
A second.
Is there any discussion on the motion to approve proposed order 8952? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions? The motion passes 4-0. Thanks once again. I think we're now at the end, right?
Thank you, Mr. Chair. Yes.
Number 2, in the matter of the application of United Water. Proposed order number 8962.
And this closes the docket, right?
Yes. Good afternoon.
Good afternoon.
Please identify yourself since I don't remember your name.
Larry Finnick, I'm Director of Operations
Oh.
for Suez Delaware, formerly United Water Delaware.
That's right. Sorry, Larry. All right. Okay, you got that, Gloria?
Yes.
Okay.
Thank you.
Please go ahead.
All right. Good afternoon, Chairman and Commissioners. After reading the staff memo dated September 26th, as well as the proposed order number 8962, Suez Delaware is in agreement with both documents.
And we'll follow up with Mr. Willard, who I should have probably called in the first place.
That's right. Yes, Mr. Chair and Commissioners, back in December of 14, the PSC opened up this docket and approved setting the DSIC at 7.5%, subject to annual review. And then in June of 2016, the staff got more information about plant additions, and it was all reviewed. The staff did remove the meter replacements portion of the additions because it did not conform to the requirements, and that adjusted the rate slightly. And at this point, the staff recommends the approval of the 7.5%. It can't go any higher than that, but it should be able to continue going forward at that rate, the staff believes.
Thank you,
Staff
Mr. Willard.
recommend adoption of the order.
Thank you, Mr. Willard. Ms. Iori?
The DPA has no comments.
Commissioners?
I have a question for Mr. Bowman. On page 2 and 3 of your memo, you have a good discussion on the depreciation. I presume that the depreciation method which they are using and you have accepted is a standard for the university, industry, or other water companies are using that. Am I correct? For example, the straight line method, is it a...
Yes.
Okay,
Sorry.
I thought so.
Just waiting for you
Thank you.
to end your question.
Move we adopt order number 8962 as presented.
Seconded.
Is there any discussion on the motion to approve proposed order 8962? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes unanimously. Excellent.
Thank you, Chairman.
Bless you.
Thank you, Mr. Willard. Thank you, Mr. Bowman. Number 3, in the matter of the application of Artesian Water Company, another disc matter. The commissioners welcome Mr. Spate.
Good afternoon.
Good afternoon.
Artesian's here, representing Artesian Water. I'm David Spake, CFO of Artesian Water Company. We've read the order, agree with staff's position and findings in it. There was an error in our calculations, which staff appropriately pointed out, and we've agreed to correct them going forward. The conservative error, in other words, our rates, our subsidy was actually lower than what it could have been, and the returns to the customers are not as much as we had originally calculated. Staff correctly pointed out an error that we had in our calculations. So in the next filing, those calculations will be reset. So that's embodied in the order, and we agree with the findings.
Mr. Willard.
As Mr. Spake said, if that's correct, there was a recommended rate of 0.34 that was adjusted down to 0.18. It was approved for 2015. Staff reviewed everything for this year and shared their findings with the public advocate and the company, and I believe there was no dispute among the parties to this, and the staff recommends adoption of the order.
Thank you, Mr. Willard. Ms. Iori?
Thank you, Chair Winslow. The public advocate has no comment.
Commissioners, any questions?
Chair, I move that the commission adopt order number 8963 as submitted.
Second the motion.
Is there any discussion on the motion to approve proposed order 8963? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes 4-0. Thank you, sir. Mr. Willard. Oops, I'm sorry. Next is in the matter of the application of Chesapeake Utilities for evaluation, process, and pricing structure for propane community gas system acquisitions. Mr. O'Brien.
Thank you, Chair Winslow and members of the Commission. Bill O'Brien on behalf of Chesapeake Utilities Corporation. What you have before you is proposed order number 8965, which is a typical opening order in that it assigns a hearing examiner. It directs the company to publish notice of the filing, and it establishes a deadline for intervention. As you can see from the body of the order, it's not a typical case before the Commission. I won't go into it now, but in large part it has to do with what the appropriate accounting treatment is from a rate-making perspective for the company's acquisition of unregulated propane distribution systems in Delaware and its conversion of those systems to natural gas. I thank staff counsel and counsel for DPA for putting the order together, and we have reviewed it and agree with it, and we ask you that you adopt order number 8965.
Thank you, Mr. O'Brien. Ms. Mayrack?
Thank you, Mr. Chairman and Commissioners. As Counsel for Chesapeake has stated, this is an opening order in docket number 16-0161. Chesapeake filed a petition with the Commission asking for consideration regarding the acquisition of propane community gas systems and their conversion to natural gas. There was a meeting that was held, and staff and the DPA requested additional information, which the company did provide. And at this point, staff would view this as ready to go forward. This order would appoint a hearing examiner, publish notice of the docket, allow other parties the opportunity to intervene and set a deadline for those interventions, and then allow that process to proceed before the hearing examiner, where we would hopefully bring recommendations and a finding back before the Commission at a later date. So staff would also urge the adoption of order number 8965. Thank you.
Thank you, Ms. Mayrack. Commissioners, any questions? Oh, Ms. Iori, I'm sorry.
Thank you, Chair Winslow and Commissioners. The DPA deserves no kudos for drafting a new order. All of the kudos go to Ms. Mayrack. The DPA did have the opportunity to review the proposed form of order in public notice and make comments on it, and the DPA supports the proposed form of order and public notice.
Thank you, Ms. Iori. Commissioners?
Move we adopt order 8965 as presented.
I second it.
Any discussion on the motion to approve the proposed order? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes unanimously, 4-0. Thank you, Mr. O'Brien. Okay, I think we have one more item left, and I see Ms. Woodward's coming forward. So, Mr. Willard, help us on number 5 on the regular agenda, please.
Yes, Your Honor. This is the matter of the Commission's review of the necessity for cybersecurity guidelines or regulations. Heaven knows, we all know that hacking into computer systems is a major problem in today's world. And the thought was, do we need to do something about this? Do we need to have some regulations to deal with this? And Ms. Woodward has just done a tremendous job. She got all the utilities together to discuss it. And what we found was all of the utilities are well aware of these risks, and they're already dealing with them, and they already have hired people to deal with it. And they have very diligently monitoring their facilities, they're training their workforces. We have created a list of questions we thought might be a good idea for the Commission to consider, and that the utilities could respond to those questions annually. And we put it on a website of the Commission so that the public could see these responses to these cybersecurity issues. We're very concerned with the confidentiality that the utilities need for their programs. We don't want to give up any of the confidentiality, but we'd like to publicize whatever we could publicize to the public. The utilities have seen the questions. They made some suggestions. The questions were amended, And it's my understanding now that the utilities are okay with the questions and are prepared to respond to them annually. So we would ask the commission to okay those questions. Again, we're going to release whatever we can to the public while maintaining confidentiality. And the conclusion reached was that no regulations are required at this time because these utilities are already on top of this and really taking care of it. So we don't feel regulations are required. So if you have any questions, I'm sure Ms. Woodward can respond to anything else.
Looks like we have a couple of people who have joined us. We'll identify yourselves for the record and make your comments.
Good afternoon. May it please the Commission, Carl Randall, General Counsel of Artesian Water Company. Would you like me to speak?
Yes, please.
Okay. Firstly, we'd like to compliment staff on the workshops that were convened in this matter and the participation of all of the Class A utilities in Delaware. I just wanted to offer today a couple observations and perhaps a recommendation. One of the educational pieces that came out of this is that some of the neighboring commissions, where utilities that are in Delaware also operate, have looked at cybersecurity and specifically found ways to address confidentiality for the communications between the regulators and the utilities that they are regulating. In Pennsylvania, there's a statute that specifically provides confidentiality so that filings regarding cybersecurity can be made to the commission and yet protected from disclosure to the public, even in the context of a FOIA request. Artesian does not operate in New Jersey, but I understand that there's a similar process there that allows information to be given to the regulators without it becoming public. The questions that are being asked of the utilities in Delaware are of a high level and yet can give comfort that appropriate measures are being taken. We look into the future, though, and if the Commission wanted to change those questions to address evolving concerns, you could provide a roadmap for what was being focused on. So I do not claim to be an expert on FOIA law, but I understand that recently Delaware's statutes were amended to allow for greater protection and confidentiality of governmental documents. You would not have to turn over sensitive information simply because of a FOIA request. And one of the concerns that was expressed in the workshops is because there is no statute here that would protect information, an order from your commission would be insufficient to allow materials to be withheld. The statute would, in essence, trump what you might enter. So I'm here today to recommend, if you think it's prudent, to ask the legislators to amend the statute slightly further so that if there is a FOIA request, you could withhold highly sensitive information you receive from the regulated utilities. The process in Pennsylvania is you provide the regulators one form that shows you addressed a variety of concerns, and it is signed by an officer. Then there is simply a public disclosure that says this utility did comply with the cybersecurity regulations. And that way the regulators are able to have the comfort that appropriate steps are being taken, but you're not doing anything that might educate the wrong people. So I just appeared today to offer that as a suggestion of a path that might allow greater transparency between the regulated utilities and this commission.
Thank you, Mr. Randall. Larry?
Okay. Larry Finicum, Director of Operations, Suez, Delaware. Again, I'd like to follow up Mr. Randall's comment and thank the Commission and staff for their work on this, as well as the workshops. Suez is in full agreement with the staff memo and feels that the questions that are being proposed are of a high nature and pose no credible threat at this time in regards to sharing that information.
Thank you. Ms. Ivory?
No comment.
Chairman Winslow, may I?
Oh, I'm sorry, Ms. Scott.
Thank you. Pamela Scott here on behalf of Delmarva Power. I would like to echo, I thought it was a very collaborative process that we had with Ms. Woodward and the DPA in terms of discussing the issues and what the utility companies have been doing. I also appreciate that there was great concern on behalf of staff that the questions being posed would not require that the utilities divulge any highly sensitive or confidential information. So from Delmarva's perspective, we are very comfortable with the list of questions currently being proposed. I also agree that to the extent that at some point these questions could change and seek more specifics, probably there would be a need to amend FOIA to provide for the confidentiality that would be required.
Thank you, Ms. Scott. Commissioners?
Yes, Mr. Chair. Thank you very much for that input, for coordinating the various utilities, for crafting a list of questions. I had the benefit of attending a Black Sky tabletop event in Philadelphia. Actually, it was in Harrisburg, sponsored by the Pennsylvania Public Utilities Commission. I think you were also there. It was very eye-opening for me, and I think that what steps been taken here, I would hope we only consider the first step, because what I'm concerned about as I see the states around us establishing guidelines is to raise the question, why then should we not also establish guidelines, benchmark some of the things those states are doing as best practices, and consider doing them also here in Delaware. My perception is that our utilities infrastructure are all integrated and connected. I would hope that we don't establish ourselves as perhaps the weak link that the cyber attacker can enter from and propagate somewhere else. I think the questions, as stated by the testimony here, are high level, but I have a grave concern about putting the responses up for public view, because if nothing else, they may not provide specific information, but they clearly would represent indicators as to who might be the weakest link to try and attack. So I would ask us to step back and think about whether responses, even to these high-level questions, there could be simply a check mark that says utilities are in compliance or pending responses. But I'd be very careful about the amount of information that we want to reveal to the public and even that level of disclosure. And I think the recommendations as to tighten down the FOIA where it makes sense are absolutely things that the Commission should take under consideration with the legislators. So that's all I have, Chair.
Thank you, Commissioner Gray. Yeah, we have a motion, please.
I move that we adopt order number 8955 as submitted.
I shall second it.
Okay, can we just have a minute, please?
Mr. Chair, can I
Yes, sir, go ahead.
propose that just a moment. On page 4 in this order, the last whereas, where it indicates cybersecurity questions as may be revised and the utilities' responses to those questions, I don't agree with the responses. There's also, I think, in statement 5, responses are also referred to.
Ms. Woodward, Mr. Gray asked the same question I had on my mind, and that is, I really am not an expert. I don't know how much the utilities are really revealing by making answers to those questions. You want to give me some input on that?
I really think these questions are at a very, very high level. The utilities were not against any of it at all. They see it as being a benchmark to show the public that they are being taken care of as a customer, to their utility. They're taking those concerns in, and they are, looking at things.
So it's, one of the purposes is for public assurance.
Yeah.
And then what you're saying, I believe, is that the utilities' input to you was that by answering these questions, they would not be revealing any cybersecurity weaknesses or giving any hints that would be helpful to somebody who's not friendly to us.
No, they weren't concerned about that at all.
Well, and I do think that there's reason to be concerned in that area in general. I looked at all the questions, and I'm not, like I say, I'm not an expert, but
These are actually proposed in the various other states that are around us. This is one of the initiatives that they are taking, is posting these questions in various forms. So this is kind of like a benchmark that they've set that we have decided to follow here in Delaware. That's only one benchmark. That's just the beginning. Like he said, I mean, it's gonna go from here. Things are gonna change, and
I confess that I've listened to the lady who's in charge of the cybersecurity for PHI. I guess she's still on board. She's really exceptional. She's doing some good work in this area. And I wasn't surprised at the reaction of the utilities in terms of what they're doing, because this really has been been a lot of public notice about this issue and whatnot. So.
It's actually quite incredible to see what they have done in the work groups that we had. There was, some Exelon representatives, and all the representatives from the other utilities were here, and they all stated their opinions on how they're progressing with it by hiring new employees, creating new positions, doing more research, partnering with some of the agencies that are local and some of the federal agencies. It's not something small, but they've done enough research at this point that on a state level for us, I'm not sure that we need to do anything here yet. I don't think it's come to that. I think it's above us still.
Okay. The only thing I would say, I didn't see anything in there about the utility hiring an outside independent person or entity to make attempts to hack into or to check on systems. In other words, they do, I think NIST standards, if I recall correctly, require that they have some sort of independent.
The credentials of Exelon in particular are immaculate. I don't even know if anyone could get that kind of clearance unless you had that kind of connections. I was certainly impressed with what they have. Of course, I don't want to go into detail with it and what they disclose to us, but I will say that at a high level, I don't think there's anything we need to worry about at this time. And the other utilities the same. I mean, they've really hired some very great people to their staff. They've really, done a lot of research. I was impressed that they've gone ahead and taken these initiatives. And, of course, they have reporting groups. They have sharing information groups that they share information with different episodes that come, if there's a hacking, something comes in. They have different, organizations that they share with so that they're aware of what's going on out there.
So, Mr. Chair, I'm not in any way critical or minimizing what I believe the utilities are and should be doing. I'm just a little bit skeptical about responding, because just as one can prove to the public that the utility is doing a good job, one might reveal that a utility that is not doing a good job, perhaps is not answered in an appropriate way, represents an opportunity for someone who wants to do harm. So it's just about the responses publicly displayed.
Right.
Okay.
I see Commissioner Gray's opinions. I take it, because I had questions too about whether we should post such questions or we should even get into that involvement or just stay as we were. So I think it's a step maybe in the right direction, I guess, just to disclose the fact that we are aware and that we are looking at this and that we are ensuring that the utilities are taking an active role in cybersecurity and their customers.
Just one point of clarification. I have no issue with the questions or that they're publicly displayed. It's just the responses that I have concerns with. Okay?
Yes.
You got a motion and a second.
Has someone made a motion, Gloria?
I had made a motion and Mike seconded.
That's why we're discussing it. Okay.
Yeah.
Okay, any further discussion on the motion to approve the proposed order?
As submitted, I would like the response. That's only my, as submitted, I don't.
Well, the motion's been made, and I guess as seconded, so we'll vote on the motion. All those in favor of the motion to approve the proposed order on cybersecurity as written, please signify by saying aye.
Aye.
Any opposed?
One,
And one absent, so it passes 3-1. Amy, Ms. Woodward, thank you so much for your excellent work in this matter. And I do think that obviously you understand that this is an ongoing issue, and we'll consider what Commissioner Gray had to say. And Mr. Randall, thank you. Mr. Finnegan, thank you very much for coming in on this issue. Appreciate it.
Yes, I don't doubt in a year we'll be back on this issue again.
Yeah.
Thank you, Chairman.
Thank you. Not sooner.
Okay, under the hearing schedule, we have nothing at all. Is there anyone here from the public that wishes to make comment to the Public Service Commission? Is our friend Mr. Nunez here? No, our fine executive director is present.
Chairman Winslow, Commissioners, I thank you for the opportunity to address you, as usual, on our Tuesday meetings. I would like to certainly invite Direct Energy to come forward. If you're aware, we have had an electricity affordability committee that has been going on for some time, and they selected Direct Energy as a provider of supply in the state of Delaware, and they've contracted with the Secretary of State to provide that supply. And I think they would like to share a little bit of information. I would ask them to introduce themselves and to share what information they'd like to share with us.
Great. Thank you. Good afternoon, Chairman Winslow, Commissioners, senior staff, and members of the Department of Public Advocate. My name is Ron Cerniglia. I'm the Director of Corporate and Regulatory Affairs for Direct Energy. With me is Colin Hay. He's our U.S. Commercial Director and the officer in charge of the Delaware program. So we have a high-level executive overseeing all aspects of this program. We are very excited to receive the electric supplier exclusively contracted by the state of Delaware designation. We applaud Delaware and their leadership for implementing the first of its kind energy program in the nation. We take this designation extremely seriously, and rolling out this program in a deliberate and a transparent manner. And an example of that transparency is why we're here today. In the next 15 minutes, and we're going to be very cognizant of everyone's time, we wanted to give you just a quick overview of who is Direct Energy, in case you're not aware, our philosophy and energy mission. We'll talk a little bit about the products and marketing efforts. I know driving in from the airport, I saw one of our billboards, and our TV commercials and radio commercials are running as we speak. And then also just some observations to date. So hopefully you have a copy of our presentation.
Yes, sir. Ron, we have them.
Okay, super. So next page, Colin. So who is Direct Energy? In case you're not aware, we're one of North America's largest energy and energy services companies. You can see the number of customer relationships we have, over 5 million throughout the United States and 10 provinces of Canada. We're known as a company that says that we want our customers to use less of what we sell. So when you think about that for a second, we want our customers to use less of what we sell. That's a bit counterintuitive coming from an energy company, but that is indeed our mission. And we're not new to Delaware. We wanted to convey that we have been around for quite a while. We are active here in Delaware in the residential market, the non-residential energy market. Direct Energy provides 11% of the residential load for Delmarva's SOS customers. And as you can see from some of the logos, you hopefully have seen some of our trucks, 1 Hour Air Conditioning and Heating, Benjamin Franklin Plumbing, my favorite name of all, Mr. Sparky Electric, as well as others. Our company is divided up into 4 lines of business. We have a home organization, a business organization for our non-residential customers. We have North America Distributed Energy and Power, so that's a growing area of solar, CHP, combined heat and power, to help our largest customers. And then also our newest area is North American Connected Home. Direct Energy has grown over the last 11 years, both organically and through mergers and acquisitions. So you can see the timeline that we have here. Most recently, for example, the acquisition of Hess Energy Marketing. So we are now one of the largest gas providers east of the Mississippi. In addition to that, we also own a solar company. It was called Astrum Solar. It's now Direct Energy Solar. So we're in all lines of the energy chain. Just to give you some information about Direct Energy versus our competitors and some of the folks that operate here in Delaware, you can see that Direct Energy is the largest provider to residential consumers in North America, and we're the second largest provider in the commercial industrial space. So Direct Energy, what is our background? Direct Energy is the North American subsidiary of Centrica. Centrica is based in the United Kingdom. Centrica is the 7th largest utility in the world from a global perspective, with over 30 million customers. If you've been to the UK, if you've seen British Gas, that's us. If you've been to Ireland, if you've seen Bord Gáis, that's us as well. So our affiliates operate in over 7 countries. So why are we here today? The legislature back in July 1st of 2015 passed something called the Electric Affordability Program. And the legislature had several goals in mind to help provide additional products, services, and hopefully lower bills to residential and small business customers. The legislation tasked the the Secretary of State, Secretary Bullock, along with representatives from several state agencies, including Executive Director Howitt, represented the PSC on that committee. And they were looking for a multi-year fixed price per kilowatt hour offer, value-added products and services to help customers manage their bills and additional benefits to consumers. So on December 14th of 2014, an RFP was issued. 6 energy suppliers, 5 plus Direct Energy, submitted proposals. Staff recommended, after going through all of those, Direct Energy. And a vote was taken on April 22nd where Direct Energy was selected. We worked very closely with staff, with Brenda in particular, to work on a very, very comprehensive contract between Direct Energy and Delaware to make sure that all interests, primarily Delaware's interests, were protected. And we did our soft launch on July 1st of 2016. So that's some of the background of Direct Energy, why we're here. I'm going to turn it over to Cullen Hay, who's going to give a bit on our philosophy and some of our observations to date in Delaware.
Thank you. Again, I'm Cullen Hay. I'm the General Manager for U.S. Energy for Direct Energy. Thank you for the opportunity for us to come and introduce ourselves to this body. In large part, our motivation in Delaware was not just about Direct Energy. It was primarily about switching. This state, as you all know, has an economy that's suffering, and the market has been opened in this state for quite some time, and yet switching rates are still one of the lowest in deregulated markets across the U.S. We're here in large part because we're hoping to, through this plan and through the marketing efforts that we're making, we're hoping that consumers will realize that they have choice. They may choose me now and they may choose someone else. That's fine, because once they've made a choice, they will see the benefits that the market has to offer. And I think you'll see from our product suite that what we're offering to consumers in Delaware is not only unique, but it's also an immediate savings and should have an economic boost here in the state of Delaware. So we have products. We have 3 base products. Our first base product is simply energy. It's for the consumer that's not exactly interested in any other thing. They just really would like to get electrons at a price that they really can support. We partnered with a rewards program that's sponsored by American Express. So all of our consumers who sign up for any contract anywhere in the U.S. receive plenty reward points for every dollar that they spend. So our first base product is a 17% discount to Delmarva's current standard offer, and it's energy only with plenty rewards. Our second product, for those consumers who are interested in some additional bundling that's going to allow for energy efficiency, we offer the same energy offer with plenty rewards points, but we also are offering through our 1-hour heating and cooling franchise here that we have here in Delaware, a cooling essentials repair plan, which is effectively an insurance policy that we provide at no additional cost to the consumer, who can use this if they have a heating or cooling issue during the time of this free trial. That too is a savings to the standard offer. It's priced at 8.14, and which is 16% currently against the standard offer. Our third product, excuse me, that we're currently offering is energy, that insurance plan, the plenty rewards as well. But we also are offering a third generation Nest thermostat, which Direct Energy has a partnership with Nest Labs to offer Nest thermostats to consumers. Nest thermostats are a smart thermostat that allows consumers to manage their consumption via their smartphone. The thermostats are learning. They learn your behavior. They will figure out when you're not at home and turn your air conditioner up to a higher temperature, and then they will turn back down to a lower temperature when you walk by them, their motion sensor. We offer these products in large part because we want our consumers to have control over their own consumption. Ron mentioned earlier that we want people to use less of what we sell, and these are the tools that are allowing consumers to do that. I'll add one final thing, and what Ron touched on briefly, which was the newest addition to our lines of business is called North American Connected Home. And what Connected Home is it is a fully integrated, smart approach to managing your home, and it's solely owned by our parent company, Centrica. So soon to be announced in the U.S. is products that are called Hive. And Hive are motion sensors for your home, smart lighting, a smart thermostat that will be equal in functionality to the Nest, along with cameras, along with a lot of devices that are security-based. So when we signed this contract with the state for 2 years, we agreed that we would provide these products and these savings offers, but I just want the commission to be aware that we're going to be expanding our product catalog in Delaware, and these are the types of products that we'll be bundling at very attractive rates for Delawareans to take advantage of. Some of you may have seen, I'm not really going by the deck, I'm not a deck person, but some of you may have seen our marketing that's kicked off here in the state. We have billboards throughout Delaware. We've also launched ads, both radio and TV, direct mail pieces that are identifying that choice is here. I think we have one that we might play for you, one of our television ads we thought you might find interesting. Just pretend that you really enjoyed it, because it's pretty good. It's okay. So the point is that we're trying to drive awareness. And to my earlier point, I'm not interested necessarily in gobbling up a lot of customers. That's not really what our agenda is. Our agenda is really to allow consumers in this state to be aware that there's people like us who are out there who have offers and have smart ideas for a way consumers can consume in this state, and that there is a secondary choice out there besides Delmarva's standard offer. And I think we're going to achieve that. I'll just go straight to the meat and potatoes, which is how is the program performing so far? So I'm not sure what slide that is, but it's toward the end. So as you can see, we started selling. I provided some data here that shows that really the inception of the program was July 2016. And you can see that we have steadily increased customer count each month since, including our current October run rate for this month is going to be something close to 2,000 customers. You can see from the red bars that are on the chart. The red bars show really how our state endorsed kind of message and how sales have really taken off. I do have some basic numbers that show that bundles or the products that we're offering that give the consumer more than just energy. Those too have been rising every single month. So Delawareans are taking us up on our offer to allow them to get both air conditioning insurance as well as Nest thermostats. And you can see I've provided a slide that showed kind of web traffic, which is really how we're trying to promote the program, is getting consumers to go out and do the research that they can at their own, using their own computers. And our web traffic, they're just on this slide right here, Colin. Our web traffic has gone up significantly. We're driving consumers to our website so that they can educate themselves on what they want and what they don't want. We make the assumption that in Delaware is just like every other state, where consumers do the majority of their research they do on their own. They come to their own opinions based on what they can read and what they can see, and then they buy products, usually by either enrollment over the web or they call our call centers. So we give consumers multiple avenues in which to come into our business, and I think you'll find that our offers, I think that the general message of the program, we are sticking to it. We're also investing heavily to make the program a success. So that's all I can say.
Well, thank you very much. I sat here a good number of years ago, and I listened to the first guy from Direct Energy from Canada, right?
Yes.
Come in and present to us and make the application to do business in Delaware, and to see this tremendous growth and this contract, and to hear about the bundling of the services and people saving 16%. It's a real good message. Thank you very much for coming in. Maybe some of the commissioners have questions. By the way, I heard that the Nest can read your GPS on your car. So if you're on the way home from work, the temperature can be set to go up when your GPS gets within a certain distance of the house, so that your house is nice and warm when you get home after work.
I have one. It can read anything. It's all wireless, so whatever is on your phone, it can interact with if it wants to.
I
It's
often
pretty cool.
make the joke that during the summer it's a fight between my 13-year-old daughter and myself. She turns the air conditioner down, and I can turn it up, and it's an all-day kind of back and forth.
But you can also lock it out on a schedule too. So
Yeah, I hadn't gotten there yet.
And I think you folks had a mobile display at one of the commissioners' meetings, and I did take a tour through that. It's very impressive, very impressive. The integration that you have with the digital, the Internet of Everything, of course.
That's right.
Right, that was at MacRuck and then also at Nashville.
Right.
Yes. Yeah. Good. Thank you. And thank you so much for your support and staff support. We've been working very closely with them and keeping them apprised, and so thank you, for their assistance as well.
Thank you, Ron.
Thank you. Colin, thank you very much for your presentation. Thank you, Ron. Appreciate it.
Sure.
I know that the Direct Energy is a little bit shy and probably didn't want to brag about it, but I did want you to be aware that as a part of the legislation that was put forth, we were looking for a multi-year fixed contract, which was probably the first time we've had a 2-year fixed contract in Delaware. So I think it's notable that we have a 2-year fixed price product in Delaware. I think it's also notable that we have a no exit, no cancellation fees on the product. So those were some of the reasons why it was chosen as the most beneficial for Delaware consumers. I just wanted to make you aware of that.
Thank you.
Okay, moving right along. At our next commission meeting, which is going to be on Tuesday, November the 1st at 1 p.m., we have two public hearings scheduled. We have the public hearing on Regulation Docket 49, the Retail Electric Supply Choice Docket. So I'm sure Mr. Geddes will be here, all smiles, and Ms. Iori and Mr. Brian
Already
Green.
practicing.
Already practicing. We will also have a public hearing that has been scheduled and noticed on docket number 160928, which is the Freedom Voice Systems and the GoDaddy Operating Company transfer of control, which I believe, Commissioner Gray, you had questions on at the last meeting that we had. So we will be holding a hearing on that at 1 o'clock as well. With that, sir, I turn the meeting back to you.
Thank you very much, Mr. Howitt. I appreciate that, and safe travels to all. The meeting is adjourned.
Why don't we start this on?